I am David Sanford of Sanford Heisler Sharp McKnight, chairman of the firm, a national civil rights firm. I'm here, so happy to be here with Christine Dunn. Christine is the co-managing partner of our DC office and co-chairs our sexual violence practice group. Welcome, Christine.
Thank you, David. I'm happy to be here.
So I know a lot about you. I know a lot about your life, and I certainly appreciate the time you've been with us, so many years. We're going to get into that. I want to learn more about your early life to start. Tell me about where you grew up, where you went to school, and what some of the formative influences have been in your life from an early age.
So I grew up in D.C. I've lived there since I was 7 years old. I went to a Quaker middle school and high school, and I think that was really formative. Quaker values of public service, community service, civil rights. I wasn't consciously aware of it at the time that I was being influenced by it, but looking back, realized that it really did shape my career trajectory. When I went to law school, I went because I wanted to help people and do good in the world, and I think that those Quaker values really led me in that direction.
How would you define Quaker values generally?
Well, there's a real emphasis on civil rights. They were some of the first opposers of slavery, and community service is really important. We had really expansive community service requirements in high school, and just really public service, giving back, it's very important, and that has really shaped my career.
Yeah. And when you were growing up in D.C., you're in a political environment, mm-hmm. You're at the seat of government. How did being in D.C. more generally impact your worldview?
Yeah, like my dad was a public servant for a long time. He was in the Department of Defense. So he also really taught me that it's important to give back. And he could have been making a lot more money in a private company, but he really thought it was important to give back. And so, public service, being in D.C., I think that's drilled into you, maybe even more so than living anywhere else in the world.
I think that's probably right. So you wound up going to college. Where'd you go?
I went to Yale.
And at Yale, did you have any influences that ultimately led you to further this interest in civil rights and public service?
Well, I did a lot of community service at Yale. I was a tutor for inner city kids during, I think, all 4 years there. I also tutored English as second language to recent immigrants. So again, just community service, giving back, even during my college years, was really important to me.
When did you first realize you wanted to be a lawyer?
I think I probably always knew that I wanted to be a lawyer. My older brother is 10 years older, and he's a lawyer. So that was just a career path that I knew well. And so I don't know that I have a moment where I consciously decided. It sort of was always in the background.
And so when you were going through school, it was kind of the plan.
Yes, I've always been a planner. So I think from very early on, it was part of the plan.
And so did you go to law school right after Yale?
I took 1 year off, and I worked at the D.C. Public Defender Service, which I know you also worked at once upon a time. I was an investigator.
I was too, yes.
Which was a great experience.
It was.
The prosecutors have police officers who investigate their cases, but the public defenders really don't. So they relied on college kids to investigate their cases. Right. And it was a great experience. I was living at home that year to save money. And I remember I would call my mom and say, I'm going to be late for dinner because I have to go to this crack house down, in Southeast D.C. and try to find this witness named, Joe. And she would freak out. But it was a great experience. I learned a lot. I saw a lot. It was really fun.
I had equally a great experience. I loved it. I went as the first group of undergraduates. Up until the time I went, they had Georgetown law students be the interns. Mm-hmm. Mine was the first year of actually having undergraduates between junior and senior year come down and be an investigator for a summer. Mm-hmm. And I had the same kind of experience. I would go around mostly Southeast DC, digging up witnesses, taking statements, getting them to sign statements about some rather heinous crimes that they were witnesses to. And it became a really important part of the file for the defense and a really important moment in my life thinking about the law. How did it impact your life?
It was really good to see real lawyers in action. I mean, remember the first case I worked on there was an infanticide case. This man had killed his 3-year-old niece, and there were pictures of dead babies all over the office. And it was really hard, but also I learned how important it is for everyone to have a good defense. You know, the prosecution in that case was overcharging him. So even the worst of crimes, you learn that everyone needs a defense. The system doesn't work unless everyone does their part. And that was an important lesson.
So you did that and then applied to law school. And where did you go?
University of Virginia.
And at Virginia, did you do any clinics or do any coursework that furthered your interest in these Quaker values or reflected your pre-existing Quaker values?
So I loved my time at UVA. Charlottesville is a great place to go to school. But at the time, there weren't a ton of clinical opportunities. There were just a couple. So I did a prosecution clinic there. It was one of really the only options. It was great, small town court. I remember after appearing once in front of the judge, he did this and motioned me up and he said, "Here's a pencil." He gave me a pencil as my parting gift, shaped like a gavel. It was very small
That's very
town.
nice.
It was very nice. But that wouldn't happen in DC, right?
Do you still have it?
I don't think I have it anymore. Now I think there are a lot more clinical opportunities in Charlottesville, but at the time it was limited, which is, one of the disadvantages of going to law school in a small town. But
So you came out of law school, and what was your first job?
Clerkship. I clerked on the DC Court of Appeals for Judge Michael Farrell, and that was an amazing opportunity to see behind the curtain and understand how judges think and how they decide cases.
What a great opportunity that is. We in our firm, we have about 60 lawyers, the majority of whom have done at least one clerkship. And it's something we look for. It's not a requirement to get into our firm, but it's certainly a plus factor because like you, I had a great experience, and I think it's so valuable to see what happens behind the curtain.
Yeah, and I did an appellate clerkship, and I think I knew I wouldn't ever be an appellate lawyer, but I think every trial lawyer needs to understand the appellate process because your case could end up in appeals. So it was an interesting look at a part of the law that I didn't think I necessarily would have as much interest in.
Yeah. And so what did you do after that?
I went to Williams and Connolly to Big Law, which honestly, when I started law school, if you had told me I would ever end up in Big Law, I would have laughed in your face and thought, that is not why I'm going to law school. No way.
Well, if you're going to go to Big Law, Williams and Connolly is quite a plum, right? I mean, it's certainly one of the premier law firms in America and a great, great tradition of doing trial work at the highest level.
That's absolutely true. And I got great experience there. I mean, most big law firms, even junior partners aren't getting to do witnesses in court. And by the end of my 2 years there, I was part of a trial team. I did a couple of witnesses in a federal trial. I had done depositions. I got a lot of really good experience, a lot of really good training, met a lot of people that I'm still friends with. So I don't regret the experience, but 2 years was enough.
Yeah. So you did that, and then what happened?
By the end of my time there, I was really struggling. I just didn't care about the cases I was working on. This company suing that company, I wasn't passionate about it. And it was hard to work that many hours on something I didn't feel passionate about.
Yeah.
And so by the end, I would go home and cry 4 nights a week because I didn't care about the work I was doing. And so it was time to make a change. And a friend I had at Williams and Connolly who had left and went to work at the Department of Justice in the Civil Rights Division. He called and said, "We're hiring. Are you interested?" And I said, "Absolutely." So I ended up going to the criminal section of the Civil Rights Division, where I prosecuted civil rights crimes around the country. And it was an amazing job that I really loved. Most of the cases I was doing were police misconduct cases, a lot of cases with police officers sexually assaulting people. I did hate crimes. I had a cross-burning trial in Arkansas. You wouldn't think that kind of thing still happens, but it does. Some human trafficking cases. So really interesting cases, really hard cases, because my defendants were police officers and my victims were criminals, and getting people to care about those cases was hard. There's a joke that a prosecutor could indict a ham sandwich because only the prosecutor presents evidence in grand jury. The cases I did in the Civil Rights Division, pretty regularly grand juries refused to return an indictment, which never happens for prosecutors. But the cases were just so hard. I had trying to get juries to care about it, judges to care about it. It was difficult, but really rewarding because it was, I like the good fight.
So you liked the good fight. You embraced the good fight. What happened after that continued that fight?
Yeah, so I really developed a passion for helping victims of crime get justice. Like I said, the cases we did were very hard and very victim intensive. They were not the kinds of cases where you meet your victim the morning of trial and then you just go to trial. I spent countless hours with my victims trying to help them feel comfortable going up against police officers, really trying to help them tell their stories and get justice. And I developed a real passion for that. And then when it was time to make my next transition, I came to your firm and ultimately ended up helping to co-lead this group where I still get to help victims of crime get justice. I just do it on the other side of the coin. Instead of being on the criminal justice side, I'm now on the civil justice side. And it is really rewarding.
So you obviously developed empathic engagement, sensitivity, and a certain reservoir of kindness and compassion for the work you do, given the experiences you had in part at the Civil Rights Division, because a lot of the work that you do involves the same kinds of virtues and talents and skills, right, that you must have exhibited to do as well as you did at the Civil Rights Division. Can you talk, about what it's like to help people who are survivors of some of the worst things that you can even think of, which we won't talk about in any detail here today, but some real painful trauma and suffering that they have to undergo for a lifetime. And they come to you and they tell you about intimate details associated with that, which is emotionally exhausting and difficult to hear, let alone to experience and live with every day. Talk about what that process is like and how you help people through that process.
It is hard to do this work. I have friends ask me all the time, how do you do this? You hear horrible things all day long. And they're right, I do. I hear about people's very worst moments of their life. And it is very difficult to hear over and over the hard things that people go through. But it's also really important. I sometimes talk to victims who have never had the opportunity to share their story. I am the first person they are trusting with this terrible story. And that I am honored that they are trusting me. But it's also, I think, empowering for them to finally be able to put a voice to their story. I have victims tell me all the time, clients tell me all the time, that when they see it all written down in a demand letter, that they, for the first time, feel so vindicated that someone has understood their story and that someone is fighting for them. And that's really rewarding. I had a client once tell me that she, since retaining us a couple months prior, she was smiling for the first time in 4 years since she'd been raped because she finally felt like she had someone who was fighting for her and who was on her side. And That's really why I do this work. It is hard, but it is incredibly rewarding to try to help someone get their voice back, get their power back, and get justice so that they can move on with their life.
It's very much like a therapeutic process. I don't think people realize how empowering and how therapeutically valuable the process is once you get to the right attorney to help you through the process. And being with the right attorney means being with an attorney who not only is able to properly assess your case from a legal perspective, right? That's what they're coming to us for, and that's what they think they're coming to us for primarily, and they're right about that. But when they come to us, they're also getting a lawyer and a law firm that really thinks about their story holistically, that thinks about how they've been damaged emotionally and physically and medically and professionally and reputationally and financially and from a family perspective and more. And all of those things are part of, being an effective advocate, understanding exactly what's involved in their life story and what else is going on in their life that they would like to make right, not just about getting a certain sum of money, not just about having public vindication, but also dealing with all of these other things that we can help them with because we have such a great reservoir of experts and doctors and healthcare professionals that help them. Talk about how all of that is implicated in your practice.
Well, I think all of this comes down to really being trauma-informed. And that is not a thing that all firms care about. I care very much about being trauma-informed. Any client that comes to us, any survivor that comes to us, I want them to be treated with dignity and empathy and respect. Every single person at our firm who comes into contact with a client on one of my cases, I insist that they first talk to me about what I expect in an intake and what I expect in terms of being trauma-informed. I have them do the trainings that we have on being trauma-informed. It is very important to me. I had a legal assistant a few years ago who did an intake with a potential client, and then I later spoke to that potential client. And she said to me, I've been talking to a bunch of lawyers, but after speaking to your legal assistant, I only want to work with your firm because she was so kind to me. And I thought, hooray, it's working. This is what I want from every single person at our firm that comes into contact with a survivor. From top to bottom, I want everyone to be really trauma-informed. And, when I was in law school, that's not a thing that anyone talked about. And now they have classes on being trauma-informed. And I think that's amazing because if it starts from the very beginning of people's legal careers, then that's going to change the system. Because now you have judges who are doing victim blaming and shaming, opposing counsel. I mean, I can't tell you how many conversations I've had with opposing counsel who were victim shaming. But if you get people from the very beginning of their career learning how to be trauma-informed, that's going to change over time.
What does it mean to be trauma-informed?
Really, again, it's just treating people with dignity and kindness and giving them agency. I have clients tell me all the time that the worst part about being sexually assaulted is that they feel like they've lost their power, that they are powerless. And trying to give them that agency back and that power back, I think, is part of being trauma-informed. And it's understanding that people who've been through a traumatic event, their memories might be different. They might not think in a linear way because there's a physiological response when you go through trauma, and it makes it hard to form memories in the same way you would without that trauma. And understanding that, I think you have lawyers that would talk to a potential client and think, oh, they have gaps in their story, or there's been some discrepancies, they must be lying. And there's not that understanding that it's not lying, it's that their brain had trouble making those memories because of the trauma, and really understanding the physiological response that goes into trauma, I think is important in representing these survivors.
You're co-chair of the national practice, as I mentioned earlier, or sexual violence and victims' rights and Title IX practice group. You have overseen and are overseeing so many cases nationwide. You have brought many cases against the military. Talk about what it means to bring those cases, what the challenges are legally in bringing those cases, and what some of the more high-profile matters are that you're working on now.
Well, I first want to say I have always had enormous respect for our service members. I mean, they sacrifice so much for our country. And the first military case that I worked on, I started to understand and learn about all the legal challenges for service members to bring claims. And frankly, I was outraged that service members who give so much to our country, to make it that hard for them to pursue legal claims just isn't fair. So it is something I feel very passionate about. Back in 1950, the Supreme Court decided a case called Feres versus United States. And there, a service member was killed in a barracks fire because of faulty wiring. Clear negligence. And tried to bring claims. And the Supreme Court, in complete judicial overreach, decided that he could not bring claims, or his family could not bring claims on his behalf. And they said soldiers shouldn't be allowed to bring anything incident to military service. That's the term they use. And that term has been used to basically bar service members from bringing any sort of negligence claim about anything. I mean, most egregiously, it's been used to block sexual assault claims. So essentially, the argument is, if you are raped in your barracks, that somehow that's incident to your military service. And that is outrageous to me, that anyone could consider being sexually assaulted as part of your service to this country.
Well, there's much that's outrageous about it, but maybe among the more outrageous things about that is that lawyers representing the military have so warped any kind of reasonable interpretation of that Feres Doctrine in 1950 to basically insulate the military from any and all claims, including claims of sexual assault. Clearly, the Supreme Court of the United States, when they talked about, not being able to bring claims incident to military service, did not envision that would insulate the military from a rape claim.
I don't know what they had in mind in 1950, but it has been used to really bar service members from any sort of claim. And it's just, it is outrageous. And advocates have been trying to overturn the Feres Doctrine for 75 years on both sides of the aisle. You have Scalia, you have Thomas, both really opposed to the Feres Doctrine.
Well, it seems like a good time to bring a case. What kinds of cases do we have now that may wind up before the Supreme Court challenging that very hideous doctrine?
So I have, two similar cases, but I have one case out of Washington State where I represent 45 servicemen, most in the Army, a couple in the Air Force, who were sexually abused by a doctor. It was a pain management doctor. So my clients were in severe chronic pain. They were at vulnerable states because they were in such pain. And they went to this doctor to try and get relief from this terrible pain that they were in. And they would go in for shoulder pain, and he would make them drop their pants and examine their genitals. And these patients thought, that's weird. That made me feel really uncomfortable, but he's a doctor and he's a major in the Army. So maybe that's a normal examination. There was a knowledge differential there. I mean, doctors have the medical knowledge. And so this happened over and over and over again. And I represent 45 of them, but he probably had 100 or more victims. And he was sentenced a year ago. He pled guilty and was sentenced to 13 years in jail. And that is justice with respect to him. But what about the Army? I mean, the Army had red flags all over the place, and they ignored them, and they allowed him to keep practicing and keep seeing patients. And that is not okay. So I am trying to help these men get accountability from the Army, because if you hold institutions accountable, this kind of thing won't keep happening. And so we are bringing claims. Right now, we're still in the administrative process. Depending on how that goes, we could end up filing a lawsuit and fighting the Feres Doctrine.
Well, let's hope we win in the first instance. But if we don't, let's hope it does wind up before the Supreme Court, where Justice Thomas has an opportunity to help overturn this doctrine.
Yeah, I think sexual assault is really a great place to start attacking the Feres Doctrine, because it's so outrageous to claim that being sexually assaulted is part of your military service. So start there, make a crack, and hopefully that crack will spread and obliterate the Feres Doctrine.
Do we have any other cases against the military?
We do. So like I said, I have two similar cases. So that's one doctor case. But I also have a case out of Fort Hood in Texas where Army OBGYN was sexually abusing female patients, including videotaping them without their knowledge or their consent, videotaping, their intimate parts. And these women had no idea. They just one day they got a call from CID, that's the Army Investigative Agency, saying, "Is this picture you?" And they learned that this doctor was filming them without them knowing. And these poor women, I have one woman who said that the birth of her son will forever be tainted knowing that he did this to her. That when her son grows up and asks about when he was born, she is going to have to tell him the story of his birth and this horrible thing that happened to her. And she's afraid to have more kids. I mean, that's outrageous. But that case, some of the victims were wives of service members. So the Feres Doctrine doesn't apply to them, while other victims were service members themselves, and Feres does apply to them. So it's such a concrete example. You have apples to apples that you're comparing, but this group can't bring claims because of the Feres Doctrine, and this group can. That's not fair.
So there's a lot of hard work and institutional blocks that prevent service members from getting justice. There are also really difficult cases decided by the Supreme Court regarding arbitration, regarding class actions, and so on, that make our practice more difficult. How has the trend in the law, as it has been in the last 10, 15 years especially, becoming so conservative now with a very conservative 6-3 majority on the court, but with so many 5-4 split decisions going against civil rights litigants and class action litigation, how has all of that impacted your practice, and what have you done to help overcome that?
Well, like for example, with the Feres Doctrine, there are a lot of lawyers who won't touch military cases because the Feres Doctrine is so hard. I believe things don't change unless someone's willing to fight the hard fights. So, sure, the landscape right now is grim, but it's more important than ever to fight in those situations, because someone has to do it. It's not going to change if no one speaks up. So, I am bringing these military cases. I don't know that I'll succeed, but I think it's important to fight the fight.
Well, you're certainly a national leader on so many of these issues. You were recognized as a national leader recently, and actually over time, the last few years, as a national leader in this space by legal publications. You have been on national TV shows. Recently, you were asked to be a part of a CNN roundtable discussion. Talk about that.
Yeah, it's, I think, important to publicize these cases. I think just to bring transparency to these issues. I don't think anything changes unless you shine a light on it. That's the very first step towards change. And so publicizing these cases and bringing awareness is really important. And I've been lucky enough that our cases have intrigued the media, and the 2 doctor cases I mentioned, both of those have gotten a lot of publicity. I think that helps to bring pressure on the institutions. And it's important to get the word out there. So I've been lucky that I have gotten to appear on some news programs and really to talk about my cases and how important they are, and to just bring awareness.
You've also been a part of a very high-profile race discrimination case against the U.S. Marshal Service, which we've been involved in really since the founding of the firm. And we've been successful, but it's now on appeal before the appellate branch of the EEOC. Talk about that a bit.
Yeah, so I first started at your firm back in 2008, and I was on the Marshall's case. And I was at the firm for a couple of years, and then I left to have my daughter, and I thought I'd come right back, but it turned into 7 years at home with her. And then I came back to the firm, and I came right back onto the Marshall's case as if I'd never left. And God, that was 10 years ago, and I'm still on the Marshall's case. I mean, it is outrageous how long this has taken. We have finally reached a settlement. We are just waiting. You know, you and I joke all the time that 2026 is going to be our year to finally finish this case out. It is really hard to have seen justice delayed for so long for all of these clients. I mean, they call me all the time saying, when is it going to happen? And having to tell them, you know, please just keep waiting, please be patient is hard. And we've had class members who have died along the way. We have an attorney at our firm who's very beloved, Tom Henderson, who passed away and never got to see this case finish. So justice has been delayed here, and hopefully we are close.
Well, there is the adage, justice delayed is justice denied, and justice has certainly been denied for so many people who, as you say, have passed or are now enfeebled, who could have really used that money. We got a $15 million settlement result and real money for a lot of people that's being held up by one person, unfortunately, in the process. But I think 2026 is our year. I do believe that.
Let's hope. Fingers crossed.
I think we're going to get a ruling very soon, and we'll be done, and people will finally be able to recover. We also got really wonderful programmatic relief, in other words, changes in the policies and procedures at the Marshal Service that really would serve to help so many people going forward. And some of those changes were denied by the Trump administration through executive order, but some remain in place. So we have actually in place a really good deal for our clients who will receive the proceeds of part of $15 million as part of the settlement, and also benefit a lot of people who are still there, given what remains of the programmatic relief going forward.
Yeah, absolutely. I mean, we fought really hard to gain greater transparency. A lot of decisions used to be made with no accountability. And now they have to justify their decisions. They have to document their decisions. It's a lot harder to make decisions based purely on race when you have to justify it. And so that was hard fought.
You've had experiences in the criminal justice system. You've had experiences, obviously, extensively in the civil justice system. There are distinctions between the two. What, if any, advantages do you see existing in the civil justice system relative to the criminal justice system for survivors and people we represent?
I get asked this question a lot, and I think there are two really important differences in the civil justice process. One is that survivors get to be a party. On the criminal side, victims have rights. They have the right to be heard. They have the right to be notified of important events, but they are not parties. The prosecutor can, for example, take a plea deal even if the victim doesn't agree. They have to tell the victim, but they don't have to do what the victim says. And that can be really hard for survivors, that they don't get to call the shots. On the civil justice side, they do get to call the shots. They get to be in power. They get to drive the bus. And that is really important for survivors who are looking to get their power back and get their voice back. So that's one really important distinction. The other is that I think the civil justice process is the best way to create institutional change. As a prosecutor, I was making a difference to one victim in one crime, but I wasn't making a global difference. On the civil justice side, you really do have the power to create institutional change. When you have, for example, a school who is a defendant, I've settled cases where as part of the settlement, the school has agreed to change their policies, do audits, do trainings, do assemblies for all the students to educate them about sexual assault and the risks. Those are changes that really have the power to keep future generations of students safer. So I think that the civil justice side has the power to create really long-lasting systemic change in a way that the criminal justice side does not.
In addition to those advantages, there's also the advantage of calling the shots when it comes to determining the resolution. So a lot of our clients come to us and, of course, want pre-suit resolution. They don't want to file anything. Their ideal is to, while they may be willing to file ultimately, their ideal is to get something resolved early and confidentially. And so they get to determine whether that happens or not. And we respect their right to make that self-determination moment and say, yes, I want this, or no, it's not good enough and I'm prepared to file. And when they file, what they really want primarily is public vindication. They want to be able to tell their story and ultimately have a jury come back and say they were wronged. And as a result, they are right in this case. I take it you see both sides, people coming who are, really prepared more to settle, some people really more prepared to move forward. How do you navigate those issues?
Well, it's really important to me to have a victim-centered practice. I want my clients to feel empowered, that they get to control the outcome. So I really listen to what they want and what they want to achieve, and I try to help them get that. But I will say that almost every client I've ever had comes to me and says, I'm coming forward, even though it's hard, because I never want this to happen to anyone else. And so creating institutional change, shining a light on the problem so that it doesn't keep happening, that is really important to survivors pretty much across the board.
Christine, it's been an honor being here with you, hearing your story. It's been an honor being your partner for all of these years, for having you be a part of our collective mission for all of these years that you've been with us. And I look forward to decades more of working together.
Thank you, David. I am really grateful to be a part of this firm and get to do amazing work with amazing people. So thank you for the conversation.
Great. Thank you.